Hello and welcome to the latest edition of the Real Estate Rundown. My name's Andrew Jones. I'm a partner in the commercial real estate team here at Wright Hassel, and I'm delighted that I'm joined by my fellow commercial real estate partner, David Slade. Hi, David.
Hi, Andy.
And David's here to talk about the Landlord and Tenant Act 1954, and in particular, the Law Commission's consultation paper, which has set out some potential changes in respect of the Act. David, could you just summarise what those changes are, please?
I will do, yes. The changes that are mooted at the moment under the consultation paper, they centre around the concept of security of tenure under the 1954 Act and whether the way security of tenure is currently dealt with under the 1954 Act is working. And
when you talk about security of tenure, what do you mean?
Let me explain. Now, I suspect that most of our listeners will be commercial real estate people who know what I'm talking about, but
don't assume
well, exactly. But without wanting to sound too elementary, let's just explain what I mean by security of tenure, and it's actually explained really well in the Law Commission's consultation summary paper. So what the Act does is it gives business tenants a right to continue to occupy their property and to obtain a renewal tenancy when their existing tenancy would otherwise come to an end. That's what security of tenure means. And that right is subject to the landlord being able to oppose a renewal tenancy on a limited number of grounds which are set out in the Act. For example, if the tenant's breached the terms of its tenancy, or probably the most commonly known one, if the landlord intends to redevelop the property. So that tenant's right is known as security of tenure. And almost every business tenant is entitled to security of tenure under the 54 Act. However, where a business tenant is entitled, it's not actually compulsory. And the landlord and tenant can follow a procedure before the tenancy begins to exclude security of tenure. And the process is currently known as contracting out. And if a landlord and a tenant have contracted out, which is very common, then when the tenancy expires, the tenant will have no right to a renewal tenancy, and the parties will have to renegotiate the renewal tenancy. So if the tenant wants to remain, it'll have to come cap in hand to the landlord and negotiate a new tenancy.
So the default position with a business tenant normally is they've got security, i.e. the landlord can't just kick them out, but because they're businesses, they can agree that wouldn't apply.
Exactly,
okay.
Exactly.
And how does that contracting out process work, David?
At this stage, I think I'll just talk a little bit about the history of the Act, because it's changed over the years.
Yeah.
So
it's 70 years old, isn't it?
It is 70 years old. It's 70 years old, and in relation to security of tenure and contracting out, there have been three phases over that 70-year period. The first phase from 1954, when the Act was brought in, to the end of 1969. The second phase from 1970 right up until about 2003. And the third phase from 2003 to the present day.
Okay.
Now, the Act was introduced basically because tenants were suffering, and it was a post-war thing. So there was a paucity of commercial property in the post-war period, particularly in London, as a result of the things you'd expect: bombing, post-war austerity, etc. And things were very difficult for the tenants. So the 1954 Act was introduced to help tenants in that post-war period. And tenants were finding in the first 7, 8, 9 years after the war that they were building up goodwill in the premises. However, at the end of the term, there was no security of tenure. So landlords were choosing to let at the end of those leases to other tenants who were perhaps of better covenant strength.
Okay.
So the 54 Act was introduced to protect tenants and entitle them to these renew a lease is under this concept of security of tenure. Now, in that first phase of the Act, from 54 to 69, security of tenure was compulsory, would you believe it?
So there's no contract.
So there was no ability to contract out. So the balance was then swinging from landlord in the immediate post-war period to the tenant in that first phase of the Act. In 1969, changes were made to enable the parties to contract out of the security of tenure rights. Okay. This is the phase where we both came in, Andy, as commercial property lawyers.
Not in 1969.
Not in 1969, but a little bit earlier for me than for you.
Yes.
And what happened was you would obtain a court order to contract out of your rights under the 1954 Act. So that, I noticed almost immediately, could be quite a laborious procedure. I mean, my first seat back in 1993 as a trainee solicitor, I remember overhearing my boss often saying, "We haven't got the court order, therefore we're going to let them go in under license." Mm-hmm. And getting that court order was quite a serious detriment to the timing of any transaction.
And the courts, even those days, weren't probably as busy as they are now.
No, they weren't, and you were relying on the whim of the court. And I think we have a shared experience here, in that I think word got out about a particular county court that was particularly quick at granting these court orders, and that county court was randomly, Andy,
Horsham, if I remember.
That's right, Horsham in West Sussex. Yes. So I was a lawyer working in Birmingham in the latter days of that second phase of the Act. So, you know, lots of my property dealings were local to there, and we were contracting out our leases by going to Horsham to get a 24-hour turnaround with these court orders. And the question always arose, and I'm not sure whether the question was ever answered, was whether the Horsham County Court had proper jurisdiction to contract out a lease that wasn't
yes, because there was some argument that it should be the county court that property was in.
Exactly. Yeah, so court orders were becoming a bit of a minefield. So there were then very welcome changes in 2003, which brought in the third phase of the 54 Act. Court orders were scrapped, and a procedure was introduced, which is still in place today, whereby the landlord serves a notice on the tenant. That notice is known as a warning notice. The notice spells out in pretty good layman's terms what the impact is for the tenant of giving up its security of tenure rights. So the notice is served by the landlord when the lease is all agreed. The tenant then has to sign a declaration or swear a statutory declaration to confirm that it's understood the impact of the notice.
What's the difference between having to do a simple declaration and a statutory?
The difference between the two is that if you want to complete your lease quickly after service of the notice, you need to go down the statutory declaration route. If you don't go down the statutory declaration route and just sign a simple declaration, you have to wait 14 days from the date of service of the notice until the date of
period.
Yeah, that's right. Yeah, but I mean the simple declaration often works quite well where you've got a renewal of an existing lease on pretty much exactly the same terms apart from rent. So you agree a renewal lease by reference. There's no real negotiation.
And in your experience, do people use the simple declarations often?
I find they can do. I mean, some of my clients have renewal leases where the tenants aren't represented, right, for example. So getting unrepresented tenants to attend at an independent firm of solicitors to swear a statutory declaration is quite is quite difficult for them. So,
but it does feel quite an archaic way of doing it, where you have to go in front of another solicitor and get it signed.
Yes, it does.
I guess that's why the Law Commission are looking at it.
I mean, exactly. I mean, that's one of the things they'll be looking at as part of the consultation. Yeah.
What else are they looking at?
So what they're looking at is the concept of security of tenure generally, and whether it's actually working. And the reason for the consultation now is explained again quite well in the summary. So commercial property in the UK is thought, the summary says, to be currently worth nearly 900 billion, with more of half of that being rented, 55% rented to 45% owner occupied. And beyond the value of commercial property, it's obviously still an important base for businesses which support other businesses and people by providing places of employment, leisure, facilitating trade, getting the economy running, etc. And the 54 Act is part of the bedrock of the commercial leasehold market, and it can have far-reaching impact for both landlords and tenants of business premises. For tenants, security of tenure can be extremely important to them, and it can be very difficult for tenants to face at the end of the tenancy the prospect of not having security of tenure and having to move elsewhere. However, the Commission has heard, on the other hand, that the Act causes problems for landlords as well, and that after nearly 70 years, it's had its day, and the commercial leasehold market should be left to operate without it. So, what the Commission is asking is whether there should be a new system brought into place, and it's basically given 4 different models as part of this new system.
And what are they?
The models are, first of all, no security of tenure at all. The Act is abolished. Tenants don't have any security of tenure whatsoever. So
almost a complete reverse from 1954.
Exactly, a complete reverse from the position in the early days of the 1954 Act. And there might be a contractual recourse available to the tenant in that scenario, in that they can agree an option in their lease, so a contractual option rather than statutory security of tenure to take a renewal lease at the end of the contractual term. But that would be quite a negotiation. It would be, and it's not the easiest bit of negotiation. So that's Model 1, no security of tenure at all. Model 2 is a contracting in regime. So the default position is that tenants have no security of tenure, but the landlord and the tenant can opt in to having security of tenure in the lease. So the tenant does have security of tenure. Model 3 is the current regime. It's the contracting out regime. So the default position is that the tenant does have security of tenure, and the landlord and tenant can opt out so that the tenant does not have security. And that's obviously the current position. And then Model 4 at the other end of the scale is mandatory security of tenure. So going back to the early days of the 1954 Act, security of tenure is compulsory, and the landlord and the tenant cannot agree to contract out of the security of tenure regime. So those are the 4 models, and that's the crux of what the Commission is inviting the consultation on now.
And are the Commission looking at the grounds of opposition? I'm just thinking whether if it went to that 4th option, whether there might be perhaps wider grounds.
Yes, they might well be, but that is for the next stage of the consultation. So the consultation began in the middle of November, and the consultation period ends. The deadline for responses is the 19th of February,
so get your responses
2025.
In now, folks.
So get your responses in now, and then the results of the consultation will be published, and then more detailed discussions will be had in a second phase of consultation. as to where we go with the 1954 Act. I think various things are anticipated. First of all, things like whether the existing 6-month period below which security of tenure doesn't apply anyway is too short. So leases granted for a term of less than 6 months don't confer any security of tenure.
That might go to a year.
Does that need to increase to a year to 2 years?
Okay.
And I think the general suspicion is, well, certainly I don't think we're going to be going back to the days of compulsory security of tenure, which you can't contract out of. So I think we're going to be ending up in a position whereby there still is security of tenure, but the ability to contract out of that. But if security of tenure is to stay, then the Commission will be looking at whether the grounds for opposition need to be changed beyond the development ground and all the other grounds.
And maybe the process of renewal.
Yes, exactly.
How the court plays a part in that.
Yes. So
which we won't go on to now.
No, that's fine. So it's a long process. This and the one thing I'd probably finalise on is that the Law Commission is really an independent body established by statute merely to make recommendations. The Law Commission won't set the law. When the Law Commission publishes its recommendations, the whole thing will need to go through Parliament anyway and be passed into the law. So I think we're looking at quite a long process here.
So the conclusion is watch this space and see what happens.
It is indeed. And we'll probably be back here talking about it again after the end of this consultation and the next phase of the consultation.
Brilliant. Thank you, David, for your time and explaining that so clearly. Thank you.
Pleasure.